The courts are not the only structure to which the public can complain when they want to validate their rights. Both the Ombudsman in Ireland and the Chief Commissioner of the Northern Ireland Human Rights Commission explain how they contribute to public interest law in a complementary way.
The Office of the Ombudsman can therefore act to promote social inclusion and can benefit marginalised and vulnerable groups in society and will complement the public interest law approach. You may see the fact that my recommendations are not binding as a weakness. In fact, it is a major strength of the Office. In making recommendations, I rely on persuasion, criticism, publicity and moral authority to have them accepted. This allows for me to operate pragmatically and flexibly and to avoid the legalistic and adversarial approach of the courts and, unfortunately, of many administrative tribunals. We are able to recommend remedies which would not have been given by a court and to hold bodies administratively liable even when there is no legal duty of care or statutory liability.
We would much rather secure a change in law, as we heard from other speakers this morning, a change to policy and a change in practice through lobbying and education, where we can rely on the whole corpus of human rights law, than challenge it in the courts, where the only instrument that has any real weight is the European Convention. But it's undoubtedly going to be the case that we will do both.
In addition to guidelines outlined by Mel Cousins in his presentation, other speakers offer practical guidance on how public interest law and litigation might be progressed.
So the lessons I've learned are the following. First, the need to create institutions which are dedicated to the work and which can undertake it systematically, strategically, selecting the right lawyer, selecting the right case, selecting the right forum, selecting the right defendant. These things don't happen without planning and time. Secondly, the need to work with other institutions, demonstrated by not only in South Africa, but demonstrated by Charles Epiney's book on the rights revolution, in which he shows, studying the USA, India, the UK and Canada, that rights revolutions depend as much on what he calls support structures for legal mobilization as on matters such as the Constitution, the judiciary, or public rights consciousness. He says the support structures which are critical are typically public interest litigation centers and rights advocacy organizations. If you get the other things right and you don't have those activist bodies, it's not going to make much difference. Then there's a need to build public interest law institutions which are sturdy and sustainable, financially, politically, structurally. I've mentioned the need to do casework, the need to have high-volume casework, the need for links with community organizations, the need for links with lobbying and work through the media and parliament and other institutions which can inform and change public and government behavior. And most importantly, the impact of the work of the public interest lawyers who are full-timers can be hugely multiplied if they work with sympathetic lawyers in private practice.
Should say a little bit about funding. Our work on the case has been funded primarily through grants by private foundations, and we're of course enormously grateful for that. The private bar has also played an enormous role in this. The law firm of Leaf Cabraser, which is a huge law firm based in San Francisco with offices all over, worked closely with us in preparing the complaint, and it's devoted sort of countless pro bono hours to the effort. And they do that under the direction of Bill Lan Lee, who's a partner at the firm and a former Assistant Attorney General for Civil Rights at the Department of Justice. And my own firm, the Donson Law Firm, has also devoted countless hours and resources to the suit. The firm has underwritten the entire cost of my own work on the litigation and has allowed me, since I joined the firm, to maintain a split position, both as an associate at the firm and also as senior counsel at Human Rights First.
I mean, governments are always complaining about the cost of providing legal aid, and we understand that. But I wonder if governments take into account the cost of not providing legal aid and the cost of not supporting public interest litigation. The obvious cost of not providing legal aid is the burden on the court system of unrepresented litigants, which is a really serious problem. Not only because it slows things down and ties up judicial resources, but also because it can very often, in an adversary system, it can lead to defective results, which are then the subject of an appeal and then potentially a rehearing, so that you can have 2 or 3 goes at the same exercise simply because someone was not prepared to help a litigant be represented first time round. Second, and this is especially so of public interest litigation, any society is going to pay a substantial but unquantifiable cost if there is a growing group of people who have a well-founded sense of grievance because they have been denied effective justice. Now, because you can't put a money value on it does not mean it is free of cost. And quite frankly, I think governments need to attend to the idea of the cost to them and to society of not funding legal aid and public interest litigation adequately.
And the final word goes to Michael Farrell, FLAC Solicitor.
This conference has been intended as a beginning, as the start of a serious discussion on public interest law and litigation in Ireland. It has packed in a lot of information one day, and there isn't going to be time to assimilate that or tease out in detail the implications of the various models available, much less take decisions about future strategy. But I think that the take-up for the conference itself indicates a widespread recognition that public interest law and litigation can make an important contribution to accessing justice and ending social exclusion in Ireland today.
Guidelines